Oftentimes, employees will engage in behavior that employers feel needs to result in immediate termination. These are typically egregious acts which have subjected either co-workers or other employees to dangerous situations. It could include some kind of fraud. It could include some kind of misconduct that damaged the relationship with a long-standing client and therefore hurt the company's bottom line in terms of future income. Absolutely, an employer can terminate an employee without giving them notice, without giving them any reason even for the termination. And it doesn't have to be that the employee acted in this way before. There are oftentimes situations where an employer will want to engage in progressive discipline where, for example, you try to correct the behavior by giving a verbal warning and then maybe a written warning and then ultimately the act of termination. But a lot of times it doesn't have to go in that pattern. And a lot of times the specific act of the employee does not actually fit into that pattern because the employer needs to sever the relationship immediately as a result of that employee's conduct. A lot of things need to be looked at, however, on the opposite end of it as to whether that employee has any rights to the position or whether that employee has any right to notice or whether that employee has any right to charges of misconduct or incompetence. Depending on the employer, depending on whether the employee and employer have any kind of contractual relationship, whether there's a union involved, whether there's civil service status, all of those things need to be looked at to determine what the employer has to do in order to not violate the law in taking the action of immediate termination.